you can lose part of your property forever, permanently, with no way to undo it, without ever breaking a single law yourself. All it takes is your neighbor missing a tax bill. In several states, courts have already ruled that this is completely legal. It happened to a family in rural Indiana over a barn their relatives built in 1968. They thought it stood on their own land. A court eventually disagreed, and the reason why has nothing to do with anything they did wrong. In 1948, a 7-acre farm in Pulaski County, Indiana, was carved into 11 residential lots. Whoever drew the map made a small mistake. Between the edge of the platted lots and an old farm fence that everyone assumed was the real property line, there sat a 35-foot strip of land that belonged to no lot at all. Neighbors called it their backyard for decades. The county tax map called it something else entirely. A separate, unowned by anyone in particular parcel, taxed on its own. For over 60 years, nobody in the subdivision thought twice about that strip. Then a man named Tom Bonnell bought it, and found out he legally owned land that 3 different families had been living on top of. That's loop 1. Does Bonnell get to kick a family off land they've called their own for generations? Loop 2, and the one that actually matters to you, how does a forgotten 35-foot strip in rural Indiana turn into a legal mechanism that can reach your property too? Ruby Cotner bought Lot 8 of that subdivision in 1997. A barn already stood in her backyard, built by a previous owner back in 1968, extended with a lean-to in 2010. Both structures sat, unknowingly, on the orphan strip. For practical purposes, the Cotners treated that ground exactly like their own yard, because everyone in the neighborhood had been doing that since Eisenhower was president. Here's the part almost nobody realizes matters. In most states, if you occupy someone else's land openly, continuously, and without permission for long enough, usually somewhere between 10 and 20 years, depending on the state, you can eventually claim actual legal ownership of it. That's called adverse possession. It sounds like a technicality invented for squatters. In practice, it's how half the fences and driveways in America quietly become legal. By 1978, 10 years after that barn went up, the Cotners' claim to the strip should have ripened into full ownership under Indiana law. Should have. They just never filed the paperwork to make it official. A lawsuit called a quiet title action, which is exactly what it sounds like. A court order that silences every competing claim to a piece of land and settles once and for all who actually owns it. While that paperwork sat unfiled, the strip kept running as its own line item on the county tax rolls, completely separate from Lot 8. And because nobody was paying taxes on a strip nobody officially owned, the county did what counties do. In 1993, it sold the strip at a tax auction to an investor named Jeff Kopke. In 2011, after Kopke let it lapse too, the county sold it again. This time, to the Pulaski County Board of Commissioners itself. Neither sale changed anything the Cotners could see. The barn didn't move, the backyard looked the same, but legally, ownership of the ground under that barn had just changed hands twice, without a single person who lived there finding out. No notice arrived in their mailbox, no sign went up at the property lot. The only record of any of this existed inside a county tax office, on a parcel map most homeowners will never once look at in their lives. In 2012, Tom Bonnell bought the strip from the county. He assumed it was an empty sliver of land on the far side of an old fence. A survey told him otherwise. He now legally owned a slice of 3 different families' backyards. Bonnell offered to sell each family their own piece back for $890, roughly what you'd pay for a used refrigerator, to buy back land you already thought was yours. Most neighbors just paid it and moved on. The Cotners didn't. They filed suit, arguing the strip had already become theirs decades earlier through adverse possession. And this is where the case stops being a boundary dispute and turns into something that reaches into nearly every state in the country. Because what the Indiana Supreme Court did next is the exact mechanism that can strip a homeowner of rights they never knew were at risk. A trial court actually agreed the barn should stay. It reasoned that tearing it down would cost more than Bonnell's entire parcel was worth, so it granted the Cotners something called a prescriptive easement, a court-created legal right to keep using land they didn't own, earned through years of open, unchallenged use. The Cotners appealed anyway, wanting outright ownership. Bonnell appealed too, wanting the barn gone completely. In 2015, Indiana's Court of Appeals sided with the Cotners on every count. Then, the Indiana Supreme Court took the case and reversed almost everything. The court agreed the Cotners had, in fact, done everything right to earn adverse possession by 1978. That part of their case was solid, but the justices pointed to a legal doctrine most homeowners have never heard of, buried inside Indiana's tax deed statutes. When land is sold at a tax auction in a state like Indiana, the sale doesn't just transfer whatever the previous owner had. It wipes the slate completely clean. Every prior claim, every unrecorded right, every decades-old understanding between neighbors, gone, replaced by a brand new title, as if the land had never belonged to anyone before. Lawyers call it the new and independent title doctrine. Practically, it means a government tax sale can erase private property rights that took 40 years to build. And it doesn't matter how legitimate those rights were. If you never filed to make them official before the tax sale happened, the sale erases them anyway. On February 16, 2016, the Indiana Supreme Court ruled the Cotners had earned the strip, but they never recorded it. The tax sales came first. The barn became a trespass overnight. Tom Bonnell was declared the outright owner of the entire 35-foot strip. Not a dollar in compensation. Not a grace period. A structure that had stood for 44 years and a piece of yard 3 families had mowed since the Nixon administration legally belonged to someone else. Because of a tax bill none of them ever knew existed. Here's what this means for you. Even if you've never heard of Pulaski County, this isn't a quirk of one weird Indiana case. States split into 2 camps on exactly this issue. Indiana, Washington, Michigan, Colorado, and Wisconsin all follow that same new and independent title rule. A tax sale on a neighboring parcel can wipe out your fence line, your driveway easement, even a right-of-way you've used for 30 years, recorded or not. New York, Ohio, and New Hampshire follow the opposite rule, where a tax sale can't erase a recorded easement, because courts there decided that would amount to taxing the same value twice. And it isn't only rural strips of grass. In 2015, the Homeowners Association for Presidio Terrace, a gated street in San Francisco lined with multi-million-dollar mansions, missed a tax bill on the private street itself. The bill was $14 a year, less than a single tank of gas, and somehow, the reason a street full of millionaires almost stopped owning their own street. Nobody had updated the mailing address in 30 years, so it kept going to an accountant who'd quit in the 1980s. By the time the county auctioned it off, the debt had grown to $994. 2 investors bought the entire street, the pavement, the sidewalks, the gated entrance, for $90,100, then offered to sell it back to the horrified residents for $900,000. 10 times what they'd paid for a street the residents already thought they owned. San Francisco's Board of Supervisors eventually reversed that sale, but only through a political vote. The underlying law hadn't changed at all. A $14 oversight nearly cost 35 families their own front door. So check 3 things this week. Pull up your county's GIS map and look for any unplatted strip or gap between your fence line and your neighbor's deeded property. An orphan parcel like the one in Indiana is more common than most people assume. If you share a private road, driveway easement, or HOA common area with your neighbors, ask whether the tax bill on that shared land is actually being paid and to what address, since an outdated mailing address is exactly what sank Presidio Terrace. And when you buy title insurance, ask specifically about ALTA endorsements covering boundary encroachments and easements. The standard policy most buyers sign without reading usually excludes exactly this scenario. None of that costs anything but an afternoon. It costs the Cotners a barn. So, would you have caught a $14 tax bill on your own street before it turned into a $900,000 problem? Let me know in the comments. If a case like this is news to you, subscribe. This channel exists to find exactly the legal mechanisms nobody warns you about, until it's too late. Next time, we're looking at why some farmers legally can't fix their own tractors. A federal lawsuit over a company that never actually sold you the software your equipment runs on, only licensed it to you. You'll want to see how that one turned out.